22 times. That is how many separate private conferences the Supreme Court held this specific case at, distributing it, discussing it, and setting it aside again, over and over since last November, before the justices finally agreed to hear it on June 30th, 2026, the very last day of the term, as if the decision itself had been building toward a deadline the whole time. For comparison, most cases the court eventually grants get resolved within 1 or 2 conferences, a handful of weeks at most. 22 is not indecision, it is a signal that the justices knew exactly how consequential this specific case was going to be and were being unusually careful about exactly how to frame the question before committing to it. That question, now locked in, is whether the Second Amendment protects your right to own an AR-15. This is the deep legal breakdown of how we got here, what the actual test the court will apply looks like, and why this specific pair of cases, out of all the ones sitting on the court's docket, became the vehicle for finally answering it. Quick housekeeping. I trace the actual legal reasoning behind major cases the court agrees to hear, not just the headline outcome once they are decided, because understanding the legal test being applied tells you far more about how a case is likely to resolve than any prediction based on which justices happen to be sitting on the bench or which side has the louder press release the day cert is granted. If that is useful, subscribe and turn on the bell, because this case is going to generate real developments, briefing, argument, amicus filings over the next several months, and I will be tracking it closely. 2 seconds, and let's get into the actual legal test at the center of this fight. Start with the specific question the court agreed to answer, because the exact wording matters more than it might seem, and in Supreme Court practice, the precise phrasing of a granted question often does more to shape the eventual opinion than anything argued at the podium months later. The court granted certiorari on the question of whether the Second and 14th Amendments protect the right to possess AR-15 platform and similar semi-automatic rifles. Notice what that question does not ask. It does not ask whether Cook County's specific 1993 ordinance was procedurally valid. It does not ask whether Connecticut followed the correct process in passing its own ban after Sandy Hook. It asks a much broader category-level question, whether an entire class of firearm is constitutionally protected at all, which is exactly why the court consolidated 2 cases from 2 different circuits into a single hour of argument, because it is treating this as one unified constitutional question rather than 2 separate, narrower disputes about 2 specific statutes. A framing choice that all but guarantees the eventual ruling will be written broadly enough to control litigation in every other state with a comparable ban, not narrowly enough to apply only to the 2 named defendants. The legal test this case will actually be decided under traces directly back to the Supreme Court's 2008 ruling in District of Columbia versus Heller, the case that first established an individual right to keep and bear arms under the Second Amendment, overturning decades of lower court assumptions that the right was tied exclusively to militia service, in a 5-4 decision that itself remains one of the more closely contested rulings in the court's modern history despite now being nearly 2 decades old. Buried inside Heller is a specific 2-part framework that has quietly shaped nearly every major gun rights case since. A weapon is constitutionally protected if it is in common use by law-abiding citizens for lawful purposes, and a weapon can be restricted if it is dangerous and unusual. Those 2 categories were meant to work as opposites, in common use on one side, dangerous and unusual on the other, but 18 years of litigation since Heller have shown that the line between them is far blurrier in practice than the original opinion made it sound. And the AR-15 sits closer to that blurry line than almost any other weapon currently being litigated, precisely because it is simultaneously extremely popular and specifically designed with military-derived features that give it a different visual and functional profile than a traditional hunting rifle. Here is exactly how each side is going to argue this case, because understanding both arguments in detail is the actual key to understanding what the court is weighing. The plaintiff's core argument rests on scale. Estimates of AR-15 style rifles in private hands in the United States commonly run into the tens of millions, making it one of the most widely owned rifle platforms in the country, arguably the single most popular one, more commonly owned than many firearms nobody would ever seriously argue could be banned outright. Under a straightforward reading of Heller's common use test, the argument goes, a weapon owned by that many law-abiding people for lawful purposes, primarily self-defense, sport shooting, and hunting, cannot simultaneously be dangerous and unusual because unusual by its plain, ordinary meaning implies rarity, not mass, widespread ownership. If tens of millions of Americans legally own something, the argument continues, it is definitionally not unusual in any meaningful sense of that word, regardless of how any individual legislature or advocacy group feels about it as a matter of policy. And the plaintiffs will likely lean heavily on prior lower court opinions, including some dissents in the very circuit rulings they are now appealing that have found this common use argument persuasive even while ultimately ruling against them on other grounds. The states defending their bans have a different reading, one that focuses less on raw ownership numbers and more on what those numbers actually represent. Their argument is that popularity alone cannot be the entire test, because a weapon's prevalence can result from decades of aggressive marketing and mass production just as easily as from any genuine constitutional entitlement, and treating sales volume as constitutionally dispositive would mean a state loses its ability to regulate a dangerous weapon category the moment manufacturers succeed in selling enough of it, which inverts the usual relationship between a regulation and the thing being regulated, effectively letting industry sales figures determine the scope of a constitutional right rather than the other way around. States also point to the weapon's disproportionate use in mass shooting incidents relative to its role in ordinary self-defense situations, arguing that this specific pattern of misuse is itself relevant to whether it falls on the dangerous and unusual side of Heller's line, not simply how many are legally owned overall, and they will likely cite statistics from law enforcement and public health research to support that comparison, material the plaintiffs will in turn contest as methodologically unreliable or selectively framed. Layered on top of the common use question is a second, independent legal framework this case will have to grapple with: the historical tradition test the court established in 2022's Bruen decision and clarified further in 2024's Rahimi ruling. Under this framework, a modern gun regulation survives only if the government can point to a historical regulation from around the time the Second Amendment or the 14th Amendment was adopted that shares the same underlying principle as the modern law being defended. Not necessarily an exact historical twin, but something more than a loose, generic analogy. States defending assault weapons bans will need to root their position in historical restrictions on weapons considered unusually dangerous for their own era, an approach that worked, at least partially, in Woolford versus Lopez just weeks earlier, though notably that ruling ultimately rejected Hawaii's specific historical examples, a Louisiana Black Code provision and an isolated 1893 Oregon poaching statute, as too narrow and regionally isolated to establish a genuine nationwide tradition. Whether states can find a stronger, broader historical basis for restricting an entire rifle platform than Hawaii found for its private property default rule is a genuinely open question, and it is likely to be one of the most heavily litigated points in the briefing over the coming months. The comparison to Woolford cuts both ways here, and it is worth sitting with that tension directly. On one hand, Woolford shows this court's current majority is willing to apply the historical tradition test rigorously enough to reject weak, isolated historical analogs, which could work against states here if their own historical evidence turns out to be similarly thin. On the other hand, states defending assault weapons bans have historically pointed to a genuinely different, arguably richer body of historical restrictions on unusually dangerous weapons, from prohibitions on certain edged weapons to restrictions tied to specific dangerous firearm innovations of their own era, meaning the historical record in this case may simply be stronger or weaker than what Hawaii had available, independent of how rigorously the court applies the underlying test. Now, let's talk about why this specific pair of cases, rather than any of the other assault weapons challenges sitting in various stages of litigation around the country, became the vehicle the court chose. Timing and posture both matter here. In 2025, the court denied certiorari in Snope v. Brown, a similar challenge to Maryland's assault weapons ban, and Justice Brett Kavanaugh used that denial as an opportunity to write separately, signaling that the court should, and in his own words, presumably would, take up the AR-15 question soon, in the next term or two. That prediction came true almost exactly on schedule, and the fact that a sitting justice was willing to publicly forecast the court's future direction on a question it had just declined to answer was itself an unusually direct signal, one that both sides of this fight had reason to watch closely in the months that followed. What changed between Snope and Viramontes is worth understanding precisely, because the court does not typically explain its reasoning for granting or denying cert, which means outside observers have to infer it from procedural details rather than any official explanation. The Viramontes petition was distributed for conference 22 separate times before finally being granted, an unusually long process that suggests the justices spent considerable time negotiating over exactly how to frame the question presented, likely working to narrow it specifically to the common use question rather than a broader, messier set of issues that might have made the case harder to resolve cleanly. And that kind of behind-the-scenes negotiation over the precise wording of a granted question is itself a strong indicator of how seriously the court is treating the eventual scope of its ruling. Both the Seventh and Second Circuits had already ruled against the challengers in Viramontes and Grant respectively, meaning the court is taking up two cases where it lost at every level below, a posture that gives the justices a clean, fully developed record to work from, exactly the kind of record the court generally prefers when it is about to issue a major, precedent-setting ruling rather than a narrow, fact-specific one. It is worth understanding what this cert grant does to the broader landscape of pending assault weapons litigation nationwide, because in a real sense, it renders several other ongoing legal strategies obsolete before they finish playing out. Virginia's newly signed assault weapons ban, Senate Bill 749, is currently being challenged in a federal lawsuit called McDonald v. Katz, filed by attorneys who explicitly acknowledged in their own complaint that they expected to lose at the district and circuit court level due to existing Fourth Circuit precedent, and were deliberately building a record aimed at eventually petitioning the Supreme Court for review on this exact question. That strategy assumed the Supreme Court would need a new, purpose-built vehicle to reach this question eventually, likely years down the road once the Virginia case worked its way fully through the lower federal courts. Instead, the court reached the same underlying question through an entirely different pair of cases first, cases that had already been sitting in the pipeline since 2021 in Viramontes' instance, which means the slow, deliberate, multi-year strategy behind McDonald versus Katz may end up being answered by Viramontes before that Virginia case ever gets anywhere close to Washington. A genuinely interesting example of how a nationwide legal question can get resolved through whichever vehicle reaches the court first, regardless of how carefully any single case's own legal team planned their specific path to get there. The same logic applies to Maryland's own long-running litigation, the source of the Fourth Circuit precedent, Bianchi versus Bruen and Colby versus Hogan, that has been controlling how similar challenges get treated throughout that circuit and to any other state-level case currently sitting in a lower court anywhere in the country, making essentially the same constitutional argument. Here is the realistic timeline from this point forward. Oral argument has not yet been scheduled, but is expected in the fall of 2026, early in the court's next term. A decision is expected by June of 2027, consistent with the court's typical pattern of resolving argued cases before the term concludes, though genuinely consequential rulings sometimes land right at the very end of that window rather than earlier in the term, occasionally arriving in the final days alongside several other major decisions the court has been sitting on all year. Between now and argument, expect a substantial volume of amicus briefs from both sides, gun rights organizations, gun control advocacy groups, state attorneys general on both sides of the underlying policy debate, and likely law enforcement organizations weighing in on the practical, on-the-ground implications of a ruling either direction, since a case of this magnitude routinely draws dozens of outside filings from parties who are not formally involved in the litigation but have a direct stake in its outcome. Watch specifically for briefs from the states currently defending their own assault weapons bans: California, Maryland, New York, New Jersey, Massachusetts, and Virginia among them, since those filings will preview exactly how each state's own attorney general plans to defend a comparable law if this ruling does not go their way. Information that will be genuinely useful for predicting how each state's own litigation might unfold, regardless of the ultimate outcome here. Step back and consider what is actually at stake in terms of legal precedent, beyond just the immediate fate of two specific state and local bans. A ruling that AR-15-style rifles are constitutionally protected under the common use test would represent the most significant expansion of Second Amendment protection since Heller itself in 2008, likely invalidating comparable bans in roughly a dozen states at once and forcing every one of those states to pivot toward entirely different regulatory tools, magazine capacity limits, purchase age restrictions, enhanced background checks, rather than category-based bans on the rifle platform itself. A genuinely significant shift in how gun control policy gets crafted at the state level going forward. A ruling upholding the bans would do the opposite, providing the first direct Supreme Court validation of feature-based assault weapons restrictions as a category, likely encouraging additional states to enact similar bans with considerably more legal confidence than currently exists, and reshaping how lower courts across the country evaluate similar restrictions for years, possibly decades, to come, effectively closing off the common use argument as a viable path for challengers in future cases involving this same weapon category. There is also a real possibility the court crafts a narrower ruling than either side is hoping for, one that resolves the specific question of AR-15 platform rifles without fully answering how the same test applies to other semi-automatic weapons or magazine capacity limits more broadly, which would leave meaningful room for further litigation even after this specific case is decided. A genuinely plausible middle path given how carefully the court appears to have negotiated the exact scope of the question it agreed to answer. There is no realistic middle outcome here that leaves the underlying legal landscape looking anything like it does today. This is a genuinely binary, high-stakes constitutional question that the court has spent nearly 2 decades since Heller carefully avoiding, and it no longer has that option. Let me clear up a few misconceptions about what this cert grant actually means procedurally, because getting this wrong leads to genuinely bad decisions for anyone directly affected. The first misconception is treating a cert grant as any kind of signal about how the court is likely to rule. It is not, at least not reliably. The court grants certiorari for many reasons beyond simply wanting to reverse a lower court, including wanting to affirm a ruling and settle a circuit split, wanting to provide nationwide clarity regardless of which way the underlying law leans, or responding to a case presenting an unusually clean, well-developed factual record regardless of the eventual outcome. Reading a cert grant as a prediction of the final result is a common but genuinely unreliable inference. The second misconception is assuming this case will only resolve the specific statutes in Illinois and Connecticut. It will not, in practical effect, because the court is answering the underlying constitutional question at the category level, meaning the reasoning in the eventual opinion will almost certainly control how every comparable ban in every other state gets evaluated going forward, even though each of those other states' specific laws will technically still require their own individual case to formally apply that reasoning and strike the law down or uphold it. The third misconception, particularly relevant if you are following the Virginia litigation closely, is assuming McDonald versus Katz is now irrelevant and can simply be dropped. That is not necessarily true either. That case may still matter for resolving Virginia-specific factual or procedural questions even after Viramontes is decided, since a Supreme Court ruling on the general constitutional question does not automatically resolve every state-specific procedural wrinkle in every pending case built around it, particularly if Virginia's own statute contains features or definitional choices that differ meaningfully from either Cook County's or Connecticut's approach, differences that could still require their own separate litigation to fully sort out even after the core constitutional question is settled nationally. If breaking down the actual legal test at the center of this fight instead of just the headline was useful, hit like so it reaches people who want to understand the mechanics behind this case rather than just who is suing whom, and subscribe if you have not, because the briefing schedule, the amicus filings, and eventually the oral argument itself are all going to generate real, substantive developments worth tracking individually over the coming months, not one single story that resolves itself the day it was granted. This case is going to be litigated in public view, in stages, for close to a year, and each stage genuinely tells you something new about where the eventual ruling is likely to land, the same way the questioning at oral argument in Wolford versus Lopez previewed that ruling's outcome months before it was formally announced. Tell me in the comments whether you want the next video to track the amicus briefs as major organizations file them over the coming weeks, or to wait and go deep once oral argument actually happens in the fall, because both are genuinely worth covering in real depth, and I would rather build the next one around what you are most interested in following closely as this case actually develops.